me a very exciting kind of field because think of it, we're always dealing with inventive stuff, inventive people. We're always dealing with new things. We're dealing with at times art, at times it could be software, startups, pharmaceuticals. The number of different fields that I have dealt with since I started my career are really endless. What is really fun about it is that as every file I get, I learn the field, I learn the material as much as I need it for court or for the contracts that I'll be drafting. And yeah, it's like a traveler. It's kind of a a kind of a legal traveler in different fields and arenas. Tonight I'll be talking to you, but I want to warn that it cannot be advice, because in order for me to give advice, each case is very unique. I can just give you general guidelines. And when you keep to these guidelines, I'm sure that you will be very happy to find out that you have more assets that you've ever known. You'll be happy to find out how not to use by mistake other people's assets, how not to get into trouble. And why don't I say a few things on projects, as projects that you will probably be creating, and projects that are creating at hackathons, for example. It has to do with collecting information on what exists already. It has to do with collecting texts and photos and videos and data that some would like to use in their new project. It has to do with knowing what the field is, who are the owners already in the field in which you want to tap into, and what kind of new knowledge assets can be made into your intellectual property. So after giving you all of this opening, why don't we start with the first thing? What is an idea and what is an asset? So obviously all of us are very inventive. I can tell you that my fellow Israelis, I mean, there's not even one person you'll meet, a cab driver or someone, that doesn't have a solution for everything. The greatest app in the world, the greatest machine in the world. Most people in the world, I guess, are like this. The big thing is to take your idea and make it into an asset. Why is that? As long as it is your idea, and let's talk, for example, about your project. As long as you have an idea for something and you haven't really put it in writing, or you haven't recorded it in any way, or you have no proof that it exists except for maybe talking about it to yourself or to someone else, that's still within an idea. And the law all over the world, as many countries and as I know, because I am an Israeli lawyer, the law is that ideas and thoughts should obviously not be anyone's assets. They should not belong to anyone. It has to do with the free exchange of knowledge. It has to do with even democracy, with the basic right of a people to think, of another person to think. So let's say I thought of the greatest application and I told someone, and I didn't do anything with it, and someone else just went and thought of the same thing, then there's no reason, and he did do something with it and started developing it, etc. There's no reason why he would be stopped or she would be stopped. But on the other hand, if you thought about something great and you actually put it down as a business offer, for example, or you just wrote it down for yourself, and you have someone that could even be your witness later that you did it, or you documented it. We'll speak later of the ways to take care of it. So this became, from the moment you started documenting it, it became a kind of asset. It became probably intellectual property. And this evening, in the short time that I have, I'll just go over with you with the different tools that you have that will help you to create this intellectual property, and preferably with people that are busy with hackathons, with courses, etc. You don't really look for the very expensive ones that all of you have heard of. You know, there are millions of dollars invested in patents that the pharmaceutical companies, for example, have. So the smart thing is to find the small steps that any person can take care of your knowledge and to try and create it into your assets. So from ideas to assets. It says here on the upper part, actually, I had already a drawing and I added in English to it. What is the intellectual property, the IP? So there's a very simple example I like to use. A car is your actual asset, but the designs for the car that belong to the company you bought it from are the IP. And that's the very small difference. Now, I do that to show that a car might be worth, I don't know, a few thousands of dollars, hundreds of thousands, it depends how expensive. But let's think how expensive the designs are, which means that many time IP that is disregarded as an asset is a potential for a lot of money for whoever owns it. And it has to be taken care of as an asset, and it has to be guarded as one. And at times you have to create it. So let's go on. This is the kind of model that I like to use to show what goes on with everything. So once you click the light shelter on the right, then the whole innovative cycle will start happening. Because if there's innovation in the organization, then obviously it's kind of energy that will light up a kind of light bulb. And outside of this light bulb and outside of your organization, you might have many people, and it might be workers, it might be in different organizations, suppliers, it might be colleagues, sometimes it's competitors. But as you can see, there are a lot of ideas flowing around. And these ideas can become knowledge. Once you even decided that you acknowledge it as assets, these kind of floating ideas that you hear maybe in the lunchroom, and maybe when you just enter the office and you say hello to someone, and taking it with you, maybe when you go to your rooms tonight and you just talk. Some of these ideas are ideas. So what's the smartest way to move from ideas to knowledge? Just, write it. Just write in points, even bullet points. What were the ideas we discussed today, which many people don't do? Once you start writing and documenting, don't forget a few very simple things. Put the date that you spoke of today. Put the names of the people that sat together. You can also write who said what, that's fine. And these ideas will go into the light bulb, and our target is to get into the middle and to make them into intellectual property, because not every knowledge that you will actually put down, you'll be able to prove that it's only your asset, but it's the first step. So this whole thing will go round and round, because the more you have assets and the more you have intellectual property, the more you will be happy, and other people in your group, let's say if we talk about what you guys are doing in this class, or anybody in your organization, will be happy to keep on innovating. So please remember, the more seriously you take your ideas, the more seriously later you take your knowledge, the more seriously and the more fast you can make it into actual intellectual property. Now, the IP tools are something that we'll talk about soon. And could you just remind me until what time I have? Because you said 3/4, but I just want to know when I have to stop. 6:45, right? I can't hear. You're on mute. You're on mute, Edna.
Sorry for that. At 7, we need definitely to move to the
Okay, so
next
I will
part.
speak and then we'll
But
have a short.
you can split it into your presentation,
Yeah,
into
yeah,
a
for sure.
dialogue, whatever you want.
No problem. Okay, then. So let's go on. So let's find out what are the IP tools that we can use. Before that, ideas are public domain. I mean, as I told you, it belongs to no one. So we have apples that any one of you can buy in the supermarket, and you can make whatever use you want to make of them. Actually, I'm very proud of you guys, because this is my photo. I put the apples one on top of the other, and I actually took this photo myself. So guess what? At the moment, it's my intellectual property. I have copyrights on it. To the left, you'll see an apple that if I were you, I wouldn't try to mess around with it. Actually, it's apples, and that's worth a lot of money. And that belongs only to Apple. And you can make use of it only if you got a license. So the difference between public domain which are the ideas and apples. But there are other things that are public domain. What kind of things are public domain? Those, for example, that the intellectual property tools have grown old and extinct to that certain product, and then it becomes public domain. And that has to do with the balance that the law likes to make. What kind of balance does it make? It wants, on the one hand, that all these great ideas and innovations will become part of the public domain so that it becomes a giant machine that allows other people to keep on creating. Because after all, any smart person that creates anything today is basing his great creation on some kind of creations that were there before him. Because no one could do anything without the wheel, and no one can do anything without penicillin and the pharmaceuticals, and so it's one on top of the other. And imagine a world in which intellectual property tools would give someone a forever kind of ownership. I don't think we really would like that. You will see there is one kind that might give you a forever, but we'll see it in a minute. So anyway, we have also public domain for a different reason. We have today, if you go online, you'll find a lot of platforms that offer their texts, offer their photos, their works of art, their programs. We all know about open source programs that you can use, and we all know about different platforms that share. For example, the Metropolitan Museum in New York put online all of their works of art, a lot of them anyway. And it's beautiful because you can actually go online and they will have the explanation of how you're allowed to use it, and you can use it in your work. So that has to do, I think, that is directly connected to what you're doing, because if you will be looking to use in your presentations or whatever it is, any kind of photos, any kind of texts, so you can go into such public domain platforms. But remember, even those platforms, if people offer it, if it's public domain because other people just said, I allow you to use it, and it's not public domain because the period of time that in which it's in ownership of something has run out. So even people that put it on public domain, don't be mistaken. Many times they have their own conditions for use. For example, if you go on applications or databases such as Flickr, which is for photos, each one of the photographs that you'll try to use, you'll go on the site and you'll see what the licensing conditions are. Many of these people would like you to put their names under the photo if you use it in your own work. And many of them will also ask that you will put on your use of the photo a link. Okay, so all of this has to be taken care of before we move on. If you ask yourself, what about giant platforms like YouTube, like Facebook, what goes on there? So I will remind you that before you start using these applications and before you start posting all your stuff on it, you agree to the terms of use of these platforms, which means that YouTube, for example, allows other people to share, and Facebook allows it as well. So if you don't want these kind of things, you have the possibility, obviously, of having a more private kind of a page or a more private kind of channel. But don't be mistaken. Many people think, oh, but there's YouTube and there's Facebook. These things are not for free. And also, when you go onto Google Images and you find a lot of images, just because you found them, they're not free for use. So be careful there also. You always have to make sure what is the source of the text and what is the source of the photo and any kind of thing that you want to put in your own digital material. Leave the digital for a moment. The same thing goes for books, you guys. I mean, I can't decide if I'm a principal of a school and there's a great book about the Holocaust that I'll just take the book, I'll Xerox it, or I'll print it, let's say 200 copies of a whole book and give it to 3 classrooms just because the school wants to save money. That's not allowed. It belongs to the person who wrote the book. So always be careful in such uses. The intellectual property tools are divided into the following. Trademarks are names of things. So if we have Apple, or you saw the apple with the bite on it, that's a trademark, for example. You have word marks. So Apple wrote for himself a word mark on Apple, or Coca-Cola wrote for itself a word mark. And you also have the logos that you call them, that are the images. And if you want to have um, if you want to be the only one that will be able to use such marks, you have to do one of the following. One, register a mark. Two, you can decide not to register it. And when the day comes and someone else makes use of it, you will have to go to court and prove that you have goodwill in the mark, that you acquired goodwill, which means that the community around you, that the end users, that the potential buyers, if it's a product for buying, or potential readers, if it's a digital kind of platform, you have to make sure that they know who you are, that they know that this mark represents you. If you want to be smarter, put a little bit of money and register a trademark, because once you have a trademark and someone uses it, you go to court and you don't have to prove anything. You just show the judge, this is my trademark. And it's like having a registration for your apartment or for your home. So trademarks are very tricky, because when we want to choose something for our business, let's say that I have a factory that makes perfumes, and I want to register a trademark that's called funny smell, for example. Let's say a perfume for clowns. Yeah, trying to make up things. I will not be able to write it because it's descriptive of the product that I'm selling. Now, what's wrong with describing the product that I'm selling and asking for a monopoly on it? Well, it's very simple. We go back to the balance that the law makes between allowing people to make use of knowledge, allowing people even to make use of language. Imagine that everyone in his field would close all the words that describe whatever he sells. So then no one could use any more tasty for coffee if someone already registered it, and no one could use smell for perfume, etc. So one of the first rules about trademarks is that you have to choose a name that does not describe what you're selling, but it has to be connected to what you are, to who you are. It has to be distinct from other people, other sellers. How do you know what to register? Today it's quite simple. You go on Google, you see if the mark is already in use. And if you don't find it in Google, don't run and be sure that it's yours. There are a few databases. One of them belongs to WIPO. WIPO is the World Intellectual Property Organization. You can check there. The smartest thing, if you ask me, is ask your lawyer. Trademarks are registered in different places in the world. There's something called the Madrid Protocol that unifies it. So if you register it in one country, you can try from that country. Let's say I want to register in Israel, I'll have applications to other countries, but don't be mistaken. That just helps you with how to go for it. Remember, a trademark protects you in the territory in which you registered it. So if you have a great idea now for some kind of application that's connected to this course, and you'll register the trademark only here, then you're quite exposed in the United States, let's say, if someone else wants to use it. So remember, it's territorial and it's good every time for 10 years. Now, remember, I told you that intellectual property eventually expires. Well, trademarks will not expire as long as you keep paying again and again and again and again. That's why you have such old trademarks as Coca-Cola. I used it before. And you'll have such trademarks like IBM, and you'll have all these old, very heavy trademarks that, as long as their owners will keep on renewing them, they will have them. The moment you stop renewing, then it becomes again public domain. By the way, not a very cheap kind of tool, but not so heavy. Just to give you a notion of what it is, if you want to register one trademark, you have to pay the Israeli trademark office fees at the sum of 1,700 new Israeli shekel divided by about 3.5. So it will be about, let's say, $500 or something like that of fees. And you can register a trademark. And everything today is very friendly. You can try to do it on your own, but remember all the tricks that there are. You're not supposed to choose someone else's trademark that was already taken, because then you're throwing your monies and you won't get your fees back. You're not supposed to choose something that will prevent other people from using it. Let's go to the next one. The next one has to do with patents. I don't think that you will be tackling patents so much. I mean, trademarks, you might be, as I said, you might have applications, you might want to have some programs that you're building, you might have want to have some tours. All of this could have a trademark that will be connected to it. Obviously, I didn't tell you one thing about the trademark. The images have to be original images. So you have to also search before you use, let's say that you would like to use for a program of the Holocaust, let's say a tree, to show the renewal of life. So you can't just choose a tree without checking to see what other companies are using it. One more thing, I apologize for forgetting to tell you. When you want to register a trademark, you don't register it about all the things in the world. There are about 42 different categories that do have all the things in the world in them, hundreds and hundreds and hundreds of subcategories. And if you want to register it for an online course, you'll find it in, it's called clause 42 of this kind of coding of trademarks. And if you want it for clothes, it will be 23, et cetera, et cetera. So let's say you have a company like Coca-Cola and they don't want anyone to use their trademark for anything in the world. Sometimes these giant companies like Coca-Cola, like Disney, like Apple will register hundreds of trademarks. And then you can imagine that such portfolios of trademarks are very expensive. But again, for a private person, it's fine. You can just choose one and go for it. Patents. Patents are for products, for the process of manufacturing products. It's in any kind of technological field. And the catch with a patent is that on the one hand, it's great. It gives you a monopoly for 20 years for whatever you describe. It could be the product itself. Let's say, for example, the vaccines that everyone is enjoying now for COVID. So I'm sure that they have patents for some of the formulas there. Let's say you can have a patent for a lot of hardware that is used, obviously in the computer world, obviously in the cell phone world, et cetera, et cetera. And you can also have a patent if your factory knows how to assemble a very fast production line with robots, for example. But what's the catch with patent? On the one hand, you get it only within your own country, but on the other hand, you have to prove that it's new all over the world, which means that if I went now to the patent office in Jerusalem and I said, wow, I have a patent for this kind of box that locks itself from the inside, whatever, and I searched, and in Israel there are no other boxes. The search for other things that were created before is called prior art. So then I will actually file to get my patent, but then, and I'll be happy because I'll think no one can manufacture this box for 20 years. But then the patent office that has its own people searching to make sure that it's really something new can find something even in Australia. And that something that is found in Australia will mean that your invention is not new. So don't put your money before you put your money in the searches to make sure that what you're inventing is really new. It has to be something that's useful. You can't make a kind of, I'm sure you guys have seen, they have a lot on YouTube of that, and they have books about that, about kind of funny, weird kind of inventions that lead to nothing. No, the inventions have to be useful for something, and they have to show that they have an inventive step in it. What does it mean? They have to show that a normal an average person from that profession, from the trademark, let's say it's a pharmacist. So an average pharmacist wouldn't know how to invent a new kind of drug or a new kind of medicine. It took a lot of inventive steps and a lot of tryouts, etc. It can't be anything that is very trivial or very obvious, because then it will lack the inventive step. So as I told you, it's partly territorial because in your country you'll get it for 20 years, and otherwise, um, it's it has to be new, as I said. Patents usually are very, very expensive. So before you jump on board, you might like to look for other systems. As for example, keeping your invention secret, because the moment that someone knows about it and runs to register or even to apply for it before you, then you lost the run. And you can also use another tool that I will talk about soon, WIPO Proof. It's a kind of way to register it in a secure place. So if you don't have the money for patents, you can use your safe at home to keep the documents. You can use it by sending it to yourself in registered mail. These are old systems. And you can also use a new system where you send it online to the international body that is called World Intellectual Property Organization. It sits in Geneva and is a long arm of the UN. And there they will keep it for you secret. And if you need to prove that you were the first that thought of that patent, you'll get it. What's a design? A design has to do not with how a product works, but it has to do with what it looks like. So if I have this cell phone, so this cell phone has a lot of patents inside about how it actually works. The applications inside, the software is not, the hardware is protected by patents. The software is protected by copyrights, and this beautiful design that you see, including all the icons that we always have with all the apps that we have in the opening of our phone on the dashboard, this has to do with design. So designs have to do only with industrial products. And if you, for example, are an artist and you just finished to work on a great statue, you won't be able to register a design for it unless you prove that you're going to manufacture it in thousands of tiny pieces and sell it. So it's industrial. It really, really helps to protect things like special clothing. It helps to protect a lot of household appliances. It helps to protect a lot of original furniture, original things for the kitchen, for example. Anything that has to do with the getup, it's called, with the appearance of the product. Here, too, there is kind of a catch. If I have this glass, I can ask for it to be registered if I can prove that it has a very, I show you here, a very original design, and maybe for the design that it has on the glass itself. But I can't ask the registrar to give me protection that I will be the only one that can have uh, this thing here, the bottom of the glass, that prevents the water from coming out. Because this also goes already into the functionality of the glass. So the designs are all only regarding the appearance, and patents are for the functionality. Designs, according to the new Israeli law, go on for 25 years, which is a lot. They're very cheap in Israel to register. I think that the charges for the fees for the registrar are maybe 400, 500 shekel. So architects can also use it if they have a very special design for an inside room that they made, as long as it's a product that could be industrially made. Now we go into copyrights. Copyrights have to do with, I still see that I have about 4 minutes, so I'm good. Copyrights have to do with works of art. And works of art, not as I thought before I went to law school, don't actually have to be a Shakespeare piece of work, and they don't have to be a statue. They can actually just be according to, there's an Israeli court decision that someone made up tables to calculate their taxes, and these special tables were regarded as a work that is good enough to be protected by copyrights. Copyrights will protect any kind of text that you write, any idea that you can take and you can actually put it in writing will be a copyright. Any photo will have copyrights, any film will have copyright. Piece of music will have copyrights. And any director in the film industry that will have his directions as a director registered for that also. Choreography has copyrights in it. Copyrights are amazing because they're a very easy tool. They're free. You don't need anyone. You don't have to ask permission. The moment that you put your idea on in writing, the moment that you recorded yourself singing, the moment that your notes for the piece are written, and the moment that your first piece of clay became into a small statue, at that moment your copyrights are born. And they hold on for a lot of time, 70 years after the life of a person, which is a lot. So may all of us live to 120 and more. 70 years after, you can still enjoy it, which means that the people that inherit are the ones that hold the copyrights. So no one should be mistaken that if he thinks that a known musician has passed lately, then don't think that it became public domain unless he left it in his will as public domain. You will have to check who holds the rights for his work. What is toward action? Toward action are two. There's something that's called passing off, which means that let's say you didn't register a trademark, you didn't use any of the other tools, but you see that you built a whole program with pamphlets and with digital appearance and branding and everything and everything. And you see that someone, a program, let's say to teach about the Holocaust, for example, and you see that someone went online and has very, very similar things to yours, and you didn't, and his trademark is not your trademark. He uses other words, but the whole appearance of it seems very much like yours. And you also heard from a few people that they went online to the other person's place and they were sure that it was yours and found out it's not. That's called passing off because the other person tries to pass off his merchandise or his products or services as if they're yours. That's not allowed. According to the Israeli law, there's a special kind of law called the law of it's called the law of business torts, and in this law, one of the clauses is trade is passing off. Another one is trade secrets. Trade secrets are not a tort. You're allowed to have trade secrets, but you're not allowed, obviously, to hurt other people's trade secrets. So all of you know about all the documents that we sign before we tell someone about a business plan that we want, all the NDAs that all of us know about. And in these NDAs, we say we promise not to tell anyone and not to share with anyone else what you are going to tell me now, because I am aware of it, and if I will do so, I might hurt you. Trade secrets are a very smart tool to use when you don't yet have the money to use any of the other tools, or when you think that copyright is not enough, because it's not only that you want to prove that you were the first one, but you don't want your competitors to know what you're doing because you want to be the first one out to market. So trade secrets are very important. There's a lot of rules to do with trade secrets, how it works between partners, who owns what, how it works between employers and employees, who owns what, etc., etc. Do you own any secrecy to your suppliers if they supply you with things, let's say if in the pharmaceutical industry, for example, and you happen to know things about it? Did you sign for it? Do you have any duty not to tell about it, even if you didn't sign for it? It's a whole field, but it's a very smart kind of tool. Last but not least is what I told you about WIPO Proof. It's very easy. You can go online, you can find it. If you have at the moment no patience and no time to go into any of the other tools, just do the first thing. It costs about 26 American dollars. You go online, you send a electronic file that has in it whatever you want. It can have photographs, it can have designs, it can have business plans, and you send it totally secure to this organization, WIPO, and they can't even know what's in it. It's locked. And the moment that you send it to them, they'll send you back a receipt that becomes a token. And that proves that on a certain date, you send that file to them. And when you have to fight someone else that wants to make use of your intellectual property, you can always use that token. It's really brand new. Actually, Edna and I were part of a webinar regarding this thing because it's very cheap It's very available, and I think that many courts around the world will respect such a place for registration. So that's in real the last one of the tools for now. And before I leave, before I leave the time for questions, um, I did want to add that if you think that you have a very important asset, if you think that you have a very important idea, it won't hurt you to call your lawyer that probably takes care of a lot of other things in your business, and try to think of it strategically, because all the tools that I showed you, that some of them seem very simple, it's enough that you make one mistake and you might find yourself unprotected, and that's a shame. And it's enough that you made one mistake and you can find yourself being sued by a giant that the intellectual property belongs